law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome, everybody. Welcome to the Law of Self-Defense News and Q&A show for Thursday, April 29th, 2021. It has been a while, folks. Been a while. Looks like we're live on Facebook and on our members blog as we're supposed to be. So hopefully everyone can hear me okay. If somebody in perhaps Facebook wants to give me a video audio check, that would be appreciated. Once you see one person do it, folks, the rest of you need not. Meanwhile, come on in, make yourselves comfortable. I think we have a pretty good show today. Although it's been 5 or 6 weeks since we've done one, so I apologize if things come across as a little bit rusty. Okay, people are coming in. We have quite a bit to talk about today. It's been a busy time. Those of you who've been following, thanks, David, loud and clear, following my Chauvin trial coverage, will be aware that was a pretty intensive effort. That was roughly 15 hours a day. Every day the court was in session, including all the pre-trial proceedings, folks. So thanks for coming in. For those who are new, and there are thousands of you who are new, following our coverage of the Chauvin case, thousands of new members of the law and self-defense community. So we're very pleased to have all of you. Hopefully you're aware. I am attorney Andrew Branca for law and self-defense. Get a little applause there. Oh, looks like my applause button may not be working. Well, that's too bad. All of you will have to applause silently on my behalf. That would be greatly appreciated. So at Law of Self-Defense, our expertise is use of force law. We don't do anything else. We don't have a generalized criminal defense practice. We don't do DWI or shoplifting or anything like that. Only use of force cases. And by use of force, we mean self-defense, defense of others, and defense of property, period. Now, we do that in all 50 states. That's our breadth of our area of expertise. And we help educate the public on these use of force laws through our books, through our courses, through these free open access news and Q&A shows that we do every Thursday, generally do every Thursday as we're doing now. And of course, through our membership program where folks get access to our near daily content, translating use of force legal policies and doctrines into plain English so you can understand how they apply to real world use of force situations involving real people, real courts, real cases. And therefore, arm yourself, body armor yourself. If you ever find yourself in a position where you have to defend yourself, your family, or your property, make yourself as hard to convict as possible, not through legal tricks. We don't teach legal tricks, but because you know the law, you know the actual law, not the internet law, not your retired cop buddy down the street law, not the real estate attorney's misperceptions of the law. Most of those people, what they know about use of force law, what little they know, most of it's wrong, folks. Very dangerous to rely on that. The courts don't care that you acted in good faith on bad information. They only care whether your conduct actually fell within the legal boundary. So best to know the actual law. We'll give you a couple of opportunities over the course of the show to try out our broader content at not just zero risk, but negative risk opportunities to do that. I'll address those as we step through the show. Now, this is our news and Q&A show. This is the one piece of content we produce every week that is open access. You do not need to be a law and self-defense member. And of course, we do this to help educate the public generally, but also to expose you to how we do things and therefore to perhaps encourage some of you to actually become law of self-defense members, which is extremely inexpensive. But that's why we do the show every week. So you might want to mark your calendars. If you can't catch the live show, then we do also make the recording of the show available each week. It usually takes us an hour or 2 hours to do the post-production on the recording. Also, we do a written transcript, a automated kind of rough transcript of the show each week for those of you who prefer to read rather than to watch. And we also take the audio of that show, of each week's show, and we do make it available also in a free podcast format. So if that's of interest, you can learn more about that at lawandselfdefense.com/free podcast. That's not the podcast for our members, which is separate. That podcast for our members goes out every day, just about every day, with new content. This is the free podcast just for this weekly news and Q&A show. It goes out every Thursday. And that podcast, the free podcast, is available on most podcast platforms that you can imagine. But you can find links to whatever podcast platform you prefer, as well as a simple RSS feed, if that's your preference, at lawofselfdefense.com/free podcast. So what we do in this news and Q&A show is we step through some use of force events in the news, things that have caught my interest. We're just kind of catching up on things after the 4 or 5 or 6 weeks that we were covering the Chauvin trial. So we cover some news events, and I explain how the law of self-defense would apply to those events as best we understand them, given the limited information we sometimes get from the media. But that gives us an opportunity to kind of explore some of these legal principles in a real-world context. And after we're done with my news items, then we go to Q&A. Now, we have questions that have been sent into us beforehand. We do compile those. Our members, at least our Platinum members, have a Platinum member Q&A form they can use to either send me questions that they might want answered privately, in which case we do that, or to suggest questions for the show, in which case we prioritize covering those. But anybody can email us questions at show@lawofselfdefense.com. Let me pull that down to make this a little clearer, and I'll pop that slide back up. So you can always email us questions to the show for our consideration. We can't promise to cover those, but that would be email to show@lawofselfdefense.com, and we'll compile those and do our best to answer the ones that seem most appropriate for a given show. And you can also, if you're watching this live, either on Facebook, on our members forum, you can also just ask questions live during the show. Put them in the comments. Now, I won't see them as they pop into the comments because I'm looking at the camera, not at the comments. But if we have time remaining at the end of the show, I will step through the comments, look for questions that seem appropriate for answering, and try to address them in real time during the show. I do caution that the questions we answer here are use of force questions. That's our expertise, not gun law questions. We're not experts in gun law. Use and force law is when you can use force. Gun law is what kind of gun are you allowed to own in your jurisdiction, or the magazine capacity limits, where can you carry, where can you not carry, what kind of permit do you need. We don't cover any of that, folks. I don't claim to have any more expertise in gun law than I need to be an ordinary law-abiding gun owner myself for my personal purposes. So no great expertise on gun law. A lot of expertise, I believe, on use of force law. So that's where we focus answering our questions. Again, we do the show every Thursday, 4 p.m. Eastern time, so you might want to mark your calendars to make sure you don't miss it, or catch the recording after the fact on Facebook or the Law of Self-Defense members blog. We also have it open access there, the recording after the fact, so you can take advantage of that. What else do we need to touch before we dive into news? Actually, I do want to mention our sponsor. Our sponsor is CCW Safe, but I'll do that in the context of the first of the news events. And the first news event is, you're all by now familiar, of course, with the fact that Derek Chauvin got convicted of all counts, all 3 counts. He was facing the felony murder charge predicated on third-degree felony assault, felony battery, really, a third-degree murder conviction, and a second-degree manslaughter conviction. And after several weeks of trial, over 50,000 exhibits of evidence, enough video that expert witnesses for the state, several of them testified they spent 100 or 150 hours reviewing the video evidence. After all that argument, all that evidence, the jury came back with guilty verdicts in all 3 counts within a few hours of going into deliberations. Maybe that sounds like due deliberation by a jury to you. It does not appear that way to me. Personally, I thought there was plenty of room for reasonable doubt on all of these criminal charges, but it's hard not to be sympathetic to jurors that were well aware of the prospect for horrible violence and property destruction, dying, having their house burned down, billions of dollars of damage to the city of Minneapolis. One of the expert witnesses for the state had blood sprayed all over his home, actually his former home, so I guess they went there by mistake. A pig's head left at the home. That wasn't to intimidate that witness, folks. The witness was done with his testimony. He was gone. That was to intimidate the jurors, other witnesses, and also, by the way, other jurors, witnesses in upcoming cases. We have a number of high-profile cases coming up. We have the McCloskey case in St. Louis. We have the Ahmaud Arbery trials coming up. We have the Kyle Rittenhouse case coming up that's currently scheduled to start November of this year, although delays in these kinds of cases are pretty common, so I wouldn't schedule any vacations around that. All these high-profile cases, any prospective juror going into them is well aware that they're going to be facing a very similar environment. The National Guard, the barbed wire, the concrete barriers, the being escorted to the courtroom by armed state police. Those steps were not taken because there was no risk of danger, folks. They were taken because the risk of danger was perceived to be extremely high. And indeed, of course, we had all levels of politicians, including federal Congress people, demanding a guilty verdict or there would be consequences. And the only consequences imaginable, of course, are in the context of already occurring violence would be more violence. So the question, of course, is under those circumstances, can anybody get a fair trial on the legal merits of the case? I would suggest not. The defense frequently made motions for a change in venue for this trial. They frequently made motions for a continuance, a delay in the trial. And all those were denied by the trial judge. And the trial judge's rationale was not entirely unreasonable in the sense that he said, well, what good would it do to change venue? The case has to take place in Minnesota. That's the nexus of jurisdiction. And anywhere we put this case in Minnesota, we're going to have the same circumstances. It's not like Maxine Waters would not have gone to a different town in Minnesota if that's where the trial was being held. It's not like Black Lives Matter wouldn't have shown up. It's not like the National Guard wouldn't have been needed. It's not like the jurors in that new venue would not have felt threatened if they did not return guilty verdicts on all these charges. So the judge articulated his decision to deny a change of venue on the grounds that it would be pointless, that the defendant couldn't get a fairer trial anywhere in Minnesota than he could get here. Now, that may or may not be true. I think the end result the judge gets to, based on that rationale, is incorrect, however. From my perspective, if it's genuinely true that the defendant cannot get a fair trial anywhere in the state of Minnesota, and he's obviously not getting a fair trial here, well, then the answer to my mind is you don't try the guy. You don't try a defendant when it's impossible to give them a fair trial. Justice would demand that the charges be dismissed with prejudice. And if that seems outrageous, just imagine, folks, if the races were reversed here. Imagine if the defendant in this case had been George Floyd. He'd been in a confrontation with Derek Chauvin and killed him. Now he was being tried on various degrees of murder and manslaughter. And outside the courtroom were mobs of KKK members demanding a guilty verdict to the point where the court felt it necessary to have National Guardsmen, barbed wire, concrete barriers, state police escorting jurors to and from the courtroom. Would we say that black man got a fair trial if the jurors, after weeks of argument and tens of thousands of exhibits and hundreds of hours of video review by experts, if the jury in that case had come back in a few hours and said, "Oh, guilty on all counts, Your Honor, we've reached a verdict," would that sound like a fair trial? Feel like a fair trial? Not to me, it wouldn't. And I don't think those circumstances allowed for a fair trial in this case as well. And by the way, it can be true that Derek Chauvin deserved to be convicted and deserved to go to jail for a long period of time, and still be true that this was not a fair trial. I mean, he could be guilty on the merits. I don't see it, but okay, reasonable people can disagree. But the concern for me is not so much the legal outcome. Derek Chauvin's no friend of mine. I don't have any personal investment in him. The concern for me is not the particular outcome in this case. The concern for me is the corruption of the process, folks, because any of us, if charged with a crime, can only expect the due process that we allow for the worst of us. If we deny someone due process of law, a fair trial, because we think they deserve it and have it coming, well, folks, somebody always thinks the guy is guilty or he wouldn't be on trial. And that will be true for you if you're going to trial. Somebody, at least the prosecution, thinks you're guilty. That can't be the grounds for denying due process, or there would be no due process. And we live in a world of nothing but mob justice. Justice in scare quotes, of course. So that's where we are with the Chauvin case. But of course, things are not over for Chauvin. If you hadn't heard, the federal courts, I thought I had a little slide on this. I do. The federal courts have announced that they intend to now try Chauvin in federal court. They're seeking an indictment. They have the case before a grand jury. They have had for some months, but grand juries are often slow to make decisions. That's the nature of the grand jury process. It can take place over many, many weeks. And they've announced they're definitely going to pursue civil rights charges now against Chauvin, as well as against the other officers. Now, in many of these cases, we see the feds announce an intent to pursue civil rights charges at the federal level against a high-profile defendant in a case. And they often make the decision to, well, they look at it for a few weeks, creates a little positive political buzz for the feds, and then they ultimately decide not to move forward with the prosecution. And that's generally because the underlying state trial was itself not based on substantive evidence. There was no credible rationale for a finding of guilt at the state level. And if that's true at the state level, then, well, there won't be any at the federal level either. This case is, of course, different. In this case, Chauvin was found guilty at the state level of all the criminal charges, and that's probably just encouraged the feds further to go after him at the federal level as well, including all these other charges. Now, of course, the feds won't have any better evidence than the state did, and I felt that the state's evidence left plenty of reasonable doubt in every one of these criminal charges. But I expect that really what led to this conviction was the rage of the mob and the emotional drive of the video of Chauvin's apparent conduct with his knee on Floyd. And if mob rage and the video's emotional content are sufficient to get a conviction at the state level, there's no reason to believe it won't be sufficient to get a conviction at the federal level. Again, independent of the legal merits of the case, because the process has simply become corrupted in that way. By the way, the fact that he's going to be tried now on the federal level as well brings up a point that I wanted to touch on that also gives us an opportunity to talk about our sponsor, CCW Safe, which I will do in a moment. But folks, whatever resources that Chauvin had for his legal defense at the state level, and they may have been substantial. It's kind of hard to tell. He was apparently supported by the police union and some other funding sources. I'm not familiar with how all that worked in his case. It's not of particular interest to me. He did have only one defense attorney in the courtroom who had to be on 100% every minute of that day. When the prosecution had inside the courtroom 4 attorneys on a rotating basis, so they could split up the questioning, they could split up how intensely they had to be on for any particular witness. Plus, they had another 8 or 10 or 12 attorneys working in the background, filing motions, doing all kinds of things that obviously the defense attorney couldn't do. Plus, the state had a tendency to drop enormous quantities of evidence on the defense during the trial itself, which is not supposed to be done, folks. The state dropped at least 5,000 exhibits of evidence on the defense after the trial had begun, on average 400 to 500 pieces of evidence a day. And defense counsel Nelson's one defense attorney, and he's in court all day arguing the case, and then he's supposed to do what? Go home and not sleep? Look at another 400 or 500 exhibits that night, some of which are relevant to his cross-examination of a state witness the following day, so it's not like he can afford to ignore it. Very, very prejudicial conduct by the prosecution, more than enough grounds for reversal on appeal, in my opinion. But of course, reversal on appeals they're not a do-over of the trial, folks. They're an uphill battle every minute of the way. I think there's a lot of grounds for appeal, but whether they'll be effective, whether the appellate court would be willing to take the political heat that the trial judge was unwilling to take, I think that's an open question. But in any case, whatever resources that Derek Chauvin had for his state trial, they're gone, folks. They're burned up. If the police union was paying his legal bills, and I expect that they were, they're not doing that now. He's convicted. You know, before you're convicted, you're presumed innocent. All the legal presumptions are in your favor. But once you're convicted, you're presumed guilty. So there won't be any more police union funding for either an appeal or to defend this federal prosecution. Chauvin's almost certainly dead broke. He'll have a public defender at best for either of those. And in most states, you don't have a constitutional right to a public defender for an appeal, folks. You do for a trial. That's a U.S. constitutional right. You have to have effective assistance of counsel at trial. On appeal, you could be well left to your own devices. In any case, whatever his own devices are, they won't be much. I mean, the guy hasn't worked for a long time, obviously. He's not working now. He's just awaiting sentencing now, probably looking at, A minimum sentence in the guidelines would be 10 years, serve maybe 2/3 of that, so 6 years, which may not sound that horrible, but they're looking at a lot of aggravating factors in his sentencing. The state's pursuing this very aggressively. So the guidelines could be expanded way, way beyond the 10 years or so that would normally apply to someone convicted on these charges without any prior criminal record. But in any case, if he wants to appeal, he wants to defend, obviously, in this federal trial, what kind of resources is he going to have? And the answer is going to be effectively zero. He's completely disarmed in the legal context at this point. And of course, the people pursuing him, I mean, on the appeals level, they don't need to do anything. He's already convicted. And on the federal prosecution level, well, the federal prosecutors have plenty of resources to bring against any trial that they want. So it's not a very advantageous position. And it's not a position you would ever want to be in, folks. You could find yourself getting acquitted or convicted in a state court and then face federal charges. And a whole other trial, folks, a lot more expensive trial at the federal level typically than the state level. Or you could be convicted and want to appeal, and appeals cost a lot of money as well. Are you going to have that money? Did you get self-defense quote-unquote insurance because you thought they would pay for those things? Because they might, but they might not, depending on who you went with. I mean, one of the most popular quote-unquote self-defense insurance programs, and I put scare quotes around insurance because none of them really provide insurance. I hope you're all aware of that. They make a commitment to their members to pay their legal expenses under, the conditions of membership, but they're not providing any formal insurance. But one of the most popular programs out there, USCCA, wildly popular. And by the way, they do a lot of great work. They do a lot of great training work. I've seen their training materials. I think they're excellent. I think they're frankly better than the NRA materials. I'm an NRA instructor myself. So USCCA does a lot of good work. But in terms of their coverage of legal expenses for their members, first of all, they cap those at $250,000. I think that's what they used to say. Now, I think they don't tell their members anymore what the cap is. It used to be $250,000. And folks, if you're charged with manslaughter or murder, you'll burn through a couple $100,000 pre-trial. Easy. And then if there's only, $50,000 left for your actual trial, that's not enough, folks. So the cap itself is not enough. But in any case, USCCA's current policy is if you get convicted, well, that's it. They're not going to cover you anymore. So there's no coverage for an appeal. There's no coverage for a federal prosecution, if that were to happen. And by the way, they've now, if you look at their membership terms currently in effect, if you get convicted, they reserve the right to pull back all the money they paid for your legal defense in the first place. So if they spent $250,000 on your legal defense and you get convicted, they want that money back. Are you going to be in a position to pay that money back, or is your wife going to have to sell the house to pay back USCCA? So those are reasons I cannot recommend them. Not for the training stuff. I think their training stuff is fine, but not for this purported legal criminal defense funding. It's ridiculous. And you have an option. There is a good alternative out there, and of course, that's the sponsor of our show. That alternative is CCW Safe. Okay, wrong slide. Let me try again, folks. The sponsor of today's show is CCW Safe. In full disclosure, obviously they're a sponsor of the show, so you should consider that a potential source of bias in what I say. But you can check all these facts for yourself, folks. There is no cap on what they cover for their members at CCW Safe. There's no $250,000 limit. They pay what the criminal defense costs, period. If you're convicted and say you have a hung jury, say you're not convicted, there's a second criminal trial. Well, under USCCA, you would have exhausted your funds up to the cap already, so there's no coverage for a second trial effectively. CCW Safe, we cover you if there's a hung jury and you're going to be retried again. If you're convicted and you want to appeal, CCW Safe covers you again, folks, until all legal options are exhausted. There's really no comparison between the two programs. Now, no single program is perfect for everybody, and perhaps some people don't need coverage at all. Only you can make that decision. Only you can decide if CCW Safe or any other similar program is what's best for you. But I would urge you to take a look at what CCW Safe has to offer, so at least you're making an informed decision. Don't just rely on internet marketing claims, folks, because the answers they may be giving you may not be answering the questions that actually need to be asked. So I would encourage you, point your browser to lawofselfdefense.com/CCW Safe. Take a look at what they have to offer. If you do decide to join, you can use the discount code LOSD10 to get 10% off your membership with them. Again, that's LOSD for Law of Self-Defense and the number 10. And that's where that comes up. Okay, a couple of news items. Some of these I've mentioned in prior shows, but I think they're relevant again. One of them is Ohio has now become a stand your ground state. I talked about this before that state, that new law took effect, after it had been signed by the governor, but before it took effect. Well, it took effect on April 6th of this year, folks, April 6th of this month. So just about 3 weeks ago at this point or so, which made Ohio the 38th, well, they will be the 38th state, stand your ground state once Arkansas also joins. I'll talk about Arkansas in a moment. That means there's only 12 states that are duty to retreat state, folks. So for those of you who might think that Florida stand your ground law is an aberration of the Sunshine State, it's not. It's the norm. Stand your ground is the norm in American law. Even better yet for Ohio, their version, their flavor of stand your ground is what's called, what I refer to as hard stand your ground. There's only about 10 or 12 states that are hard stand your ground states out of the 38 that are stand your ground generally. In those hard stand your ground states, it literally, the prosecutor is not allowed to mention any failure to retreat in front of the jury for their consideration as to the reasonableness of your use of force. In the soft stand your ground states, the prosecutor is still allowed to make that argument. Hey, he didn't have a legal duty to retreat, but he could have, and a reasonable person would have, and you should deny him stand your ground, deny him self-defense on that basis. Ohio, hard stand your ground state, cannot make that argument in front of the jury. They're not allowed to mention the issue of retreat in an otherwise lawful case of self-defense. So that's good. Not only is Ohio stand your ground, they're hard stand your ground. Now, one thing I would caution, if you do your own legal research on Ohio law, and this would apply to any state that has a recent change in their statutory self-defense law, use of force law, and you read court decisions, the court decisions, appellate court decisions, they always reflect the law that was in effect at the time the crime occurred. So there's already kind of an inherent delay between when the event occurs and when it would end up in the appellate courts. Could be a matter of years. And so the appellate courts are applying the law as it existed then in the past. That means it can take years for new appellate court decisions to kind of catch up with the change in the law. So if there's a self-defense shooting in Ohio today, and it would trigger the element of avoidance, there might have been a requirement of stand your ground under the old version of Ohio law, but there is not any longer a requirement for stand your ground. It's going to take years for that case to be tried and then appealed and get to the appellate courts, and then they render a decision on the appellate courts. Until that happens, all the appellate court records in Ohio are going to continue to reflect the old law, not the current law. So if you're reading those decisions, just keep in mind that for some time to come, they won't yet be reflecting the new state of Ohio's hard stand your ground law. And again, that same dilemma in the appellate court records, appellate court decisions would happen in any state where there was a profound change in use of force law. Another state where there is a profound change in use of force law coming up is, as I mentioned, Arkansas. Arkansas passed a stand your ground bill. I believe it's a soft stand your ground bill, which is unfortunate. But nevertheless, they were one of the few duty to retreat states, and now they've shifted to stand your ground. By the way, in the last 20 years, folks, we've seen a ton of states shift from duty to retreat to stand your ground, and I've seen no states go the other way. So this has been a very continuous, powerful trend. Now, Arkansas has joined that. Unfortunately, the Arkansas stand your ground law is not yet in effect. Every state does this differently. A law gets passed, signed by the governor. Sometimes they take effect instantly. Sometimes there's a delay. There was a modest delay, about a month or so in Ohio, between the signing of the law by the governor and the date it took effect on April 6th of this month. But sometimes it can be quite long. And the way they do it in Arkansas is they have the legislative session. If a bill is signed into law, it takes effect on the 91st day after the legislature adjourns from that session, which by itself is kind of a flexible date. And if you don't know when the legislature is really adjourned yet, then it's hard. You can't really start counting the 91 days. So it was signed into law, well, signed by the governor, March 3rd of this year. So just about almost 2 months ago, 6-7 weeks ago now, but it won't take effect for several months to come yet. So just be aware of that. Okay, something else from the news. Many of you, hopefully a bunch of you, may be aware that I was recently on the Tim Pool Show. This Tim Pool's a YouTube journalist, commentator, enormously popular. He's literally had billions of views of his various YouTube shows, and he's got several distinct shows. One of them he calls Timcast IRL, for Tim Pool IRL, I guess. And he invited me to be on a show earlier this week. I flew out to his compound there on the East Coast and indeed was participated in that interview. It was great fun, a little over 2.5 hours, maybe closer to 3 hours, including the members-only segment he recorded. But there's about 2.5 hours of content there that's free for you to view if you'd like to see that interview. Certainly the comments we're getting on the YouTube channel for the show are extremely positive, which is very humbling. But I know he doesn't leave these shows up indefinitely. So if you might be interested in watching that show, I would encourage you to click over and take a look sooner rather than later. It was up earlier today, I know, but it might not be up tomorrow. And you can find that at lawofselfdefense.com/pool. Now, that'll just redirect you to his YouTube channel. This is not my content, folks, so I can't just drop it on my website for all of you. You'll be redirected to his YouTube channel where you can see that show. But hopefully you go to watch it. I think you'll really enjoy it. It was a good time to be had by all. By the way, on my show alone, the interview he did of me, the one I'm linking you to with lawofselfdefense.com/pool, as of earlier today, over 330,000 views of that show, folks. So hopefully we're doing our bit to educate the public on use of force law. Let's see, what else did I want to mention? I have a note to myself to talk about the Ahmaud Arbery case. Oh, yes, I remember what it was. So in the comments to that Tim Pool show on his YouTube channel, you'll see, if you go there, you'll see a number of places where people, one of the things we talked about during the show was the Ahmaud Arbery case. This is the case with the narrative in the social hive mind is that Arbery was a black man jogging through a neighborhood and a couple of white guys shot and killed him. And of course, as always, the actual reality is far more complicated than that narrative. And from my perspective, this looks very much like a lawful exercise of Georgia's citizens arrest law. And in fact, that Arbery attacked the McMichaels who've been charged in this case, not the other way around, based on all the evidence I've seen and my understanding of Georgia law. And a lot of people, because they've emotionally bought into the narrative of black man jogging murdered by white racist, they've emotionally invested in that narrative. So they literally recoil when you suggest to them that, hey, maybe these defendants didn't commit a crime in Arbery's death. And what I saw happen in the comments is something I want to caution all of you against, and that is, it's very common to see people have a visceral reaction to some narrative, some packaging of a message, which is, of course, what happens in all these high-profile cases. And the message is packaged, not for no reason. It's packaged because, well, there are people, there are attorneys who make tens of millions of dollars off these cases. There are politicians who garner enormous quantities of political capital and power, get elected to important positions based on these cases. So there's a lot of incentive to package these things into a particular narrative. Mostly the cases we cover, that narrative is one of racist police murder, or at least racist murder. That certainly was happening in the Arbery case. And if that's what people have already been propagandized into believing, what often happens when they think they're engaged in legal analysis of this case, they're not. But when they think they are, what they do is they start with the conclusion they already believe in. They start with the conclusion that this was racist murder. And then they work themselves backwards from there. And when you do that, as you're viewing the law, viewing the evidence, you have a tendency towards confirmation bias. In other words, and this doesn't make anybody a bad person. It's a normal part of the way the human mind works. But you're not looking at the evidence in law in its entirety, in an unbiased way. What happens is that the evidence in law that supports your conclusion, because you've already emotionally bought into a conclusion, guilt here, the evidence in law that supports your conclusion, that's sticky for you. That sticks in your mind. And the evidence in law that's not consistent with your view just disappears down the stream as if it didn't exist. And that's not the proper way to do legal analysis, folks. That's just a way to reinforce a conception you already have that may or may not be supported by the law and evidence based on the actual legal merits. The proper way to do legal analysis is to start in the opposite direction. Start with the evidence and start with the law. Apply the law to the evidence as you see it and as objective a way as you possibly can, and let that process drive you to a conclusion. If you do the reverse, you're just wasting your time, spinning your wheels, and you're certainly not doing anything of legal merit. And that's why so many people who do that are shocked when it turns out that the defendant in the case is acquitted by the jury. You wouldn't be shocked if you'd done your legal analysis in the correct direction, starting with the law and the evidence, and using that to drive you to your conclusion instead of starting with your conclusion of guilt and letting that drive you to cherry pick the law and evidence that you find favorable. So don't do your legal analysis backwards, folks. It's just not very helpful. By the way, I have collected, let's see, it's hard for me to read my own slides here sometimes. I have begun to aggregate. So you may know I covered, for example, the Chauvin trial in great detail. At least one post of 4,000 or 5,000 words every day, hours and hours of video podcast content. We are aggregating all that content or links to that content on a single page that we're putting together. So I can direct you to a single link. And we're doing the same thing for the Ahmaud Arbery case. In the case of the George Floyd trial, this is not done yet. It's only about a third done, folks. I just haven't gotten to it yet. But for your records, you can make a note to yourself, lawofselfdefense.com/Floyd for George Floyd, or lawofselfdefense.com/Chauvin, if that's your preference. Both will bring you to a webpage where we've hyperlinked every bit of coverage we did for those cases in one place to make it available as a resource for all of you. And we will do the same for the Ahmaud Arbery prosecutions. We did the same thing for Zimmerman, by the way. Now, I will say that we leave that resource up on an open access basis, typically for a month or two, but eventually it does get locked down for our members. So if you are not a member, you'll lose access to that resource after a period of a few weeks. The solution to that dilemma, I would like to suggest, is that you become a member of Law of Self-Defense. It's dirt cheap, folks, under the normal circumstances. It's only about a quarter a day. It's less than $10 a month. But even better, you can try out membership for just 99 cents for 2 weeks. And if you decide in that 2-week period, it's not worth the quarter a day that we would normally charge, feel free to cancel and we'll give you back not just your 99 cents, but twice that amount, 200% money back guarantee. So we're making this a negative risk prospect, folks. You literally can't lose. Either membership turns out to be worth a quarter a day to you and you stay a member, and after the 2 weeks, you'll just be charged the normal $9 and change a month, or you decide it's not for you and you get twice your money back. So we're trying to encourage you, obviously, to make the effort to give it a shot. You simply cannot lose. And you can learn more about that level of membership at lawofselfdefense.com/trial. And by the way, during those 2 weeks, you have unlimited access to everything we've ever made available to our members. So not just the last week's worth of content or anything like that. We have literally years of plain English legal analysis, explanation all over that website. Certainly, it would be impossible to access all of it, understand all of it in just a 2-week period, but we want to give you that 2-week period to expose yourself to that content so you can make an informed decision about whether or not it's for you. So that's our 2-week trial membership for 99 cents, folks, at lawofselfdefense.com/trial. All right, let's see what else we have. If I have any more news items, I don't think I do. A little light on news today. There was some, of course, if you go to our website, you'll see blog posts on news items all the time, but those are locked down for our members. So for non-members on this show only, our open access news and Q&A show, I think those are all the news items I wanted to cover. So let me dive into some of the questions here. We got about 20 minutes left. And again, we have questions sent into us by our members using the Platinum members using the membership form. But any of you can send us questions for our consideration on the show to be answered at show@lawofselfdefense.com. Just email those to us. We'll aggregate them. And every week before the show, we flip through those proposed questions and pick out some to answer on the show. So show@lawofselfdefense.com. You don't need to be a member to take advantage of that email, but we don't guarantee that we will ask your particular question. So we had a bunch of questions sent in about the Chauvin trial, and these came in a couple forms. I won't even step through them in detail because I want to address them as general categories. One is, why didn't the defense argue this? Why didn't the defense argue that? Why didn't the defense argue that Floyd was already saying he couldn't breathe when they were still trying to shove him into the patrol car long before he was put in a prone position? Why didn't the defense talk about Floyd's pre-existing medical conditions? Well, folks, the defense largely did all those things. So I can't here step through 6 weeks of trial testimony, especially the 6 weeks from jury selection, but 3 weeks of trial testimony, including the 2 weeks of the state witnesses, half of whom were various expert witnesses of various sorts, and step through all the legal arguments again. But if you watch the actual trial, or you can access my coverage of the trial at lawselfdefense.com/blog, you'll see that the defense largely made most of those arguments. Now, they didn't make every argument, and sometimes it's hard to know. And I want to make very clear, I thought Eric Nelson did a very, very good job. He's a good attorney here. A very disadvantageous position. Basically, he's by himself facing a team of not just more lawyers than him, but frankly, kind of higher tier lawyers. I mean, many of them are in private practice at very well-paid positions in law firms in places like New York and Washington, D.C. They make a lot more money, I expect, than Eric Nelson makes. That's not to be derogatory towards him, but it's an indication of at least the perceived quality of these attorneys that the state brought in, rather than use their own state prosecutors. Only 2 of the attorneys on the prosecution team were actually Minnesota state prosecutors, folks. All the rest were volunteer private attorneys who were brought in for this prosecution. But Eric Nelson did a very good job under very difficult circumstances. And sometimes when I'm observing and I see a lawyer not make an argument I think has merit, or not point to evidence that I think is worth pointing to, or not objecting, this happened a lot, not objecting where he's fully privileged to object. So, for example, all the bystander witnesses in the case, they're supposed to be there to talk about facts, what they observed. They're not supposed to be there to talk about their feelings. And not only did they talk about their feelings, but once they started talking about their feelings, half of them broke down and openly wept on the witness stand. Sometimes the proceedings had to be paused so they could, recover themselves enough to continue their testimony. This is all very pejorative conduct, and certainly feelings are not relevant as testimony in a trial. And Nelson never objected to that feelings testimony. And when I see that, I know he can object. I know that that should not be allowed as evidence in the case. But there may be strategic reasons why he's not. Maybe he feels, well, I need to have a soft touch with these obviously emotionally distraught, traumatized witnesses. I can't come across as a mean guy or I'll lose the jury. I can't object every 2.5 minutes or I'll lose the judge, who may be then unfavorably inclined towards me on more important issues that may come up later in the trial. Also, when the state's presenting their witnesses, the state is, they're on offense. They choose the witnesses and they choose the scope of questioning. When the defense comes in to cross-examine those witnesses, the cross-examination can only cover issues that the state raised on direct. So the state can, in effect, constrain what can be done on cross-examination by limiting the scope of what they ask about on direct. Then if the defense wants to go beyond that scope, they have to call those witnesses back to be defense witnesses after the state has rested and the defense is presenting its case in chief. So I know that's a little nuts and bolts, folks. Sorry about that. But there may be strategic reasons why a prosecutor's not objecting, not pointing out certain evidence, not making legal arguments of a certain kind. Now, when I did see that in this trial, I thought to myself, well, maybe Nelson will kind of circle around later when he's in control of direct questioning and kind of fill in these blanks. And some of them he did, and some of them he didn't. And I'm not sure why he didn't. It may just be he got exhausted. It may just be, lawyers can differ in their opinions about what might be most effective. It's hard to know. One of the questions we got in specifically about this was from Tony. I normally don't give last names in this, but Tony emailed us to basically ask, before the verdict came in, before closing statements had happened, he wanted me to write about how I might have closed this case were I the defense attorney. And I did, in fact, do a post, very lengthy post, that kind of did that, kind of stepped through that process, my verdict prediction kind of post. I believe it was the Sunday before the verdict came in. And I thought Nelson's close Well, first of all, it was very long, very long. And I don't see how it could not have been long. There was just so much evidence to cover. And of course, his job is to raise reasonable doubt. So you want to touch on everything that could be a source of reasonable doubt for the jury. And there was a lot to cover. In fact, it was so long, they had to take a half-hour break in the middle. So it was 2:00 in the afternoon. Nobody had had lunch. And the judge decided the jury needed lunch. Probably the judge decided the judge needed lunch. So they basically interrupted his narrative of innocence, his narrative of reasonable doubt, kind of midway through his closing, which is hardly optimal. And then after that half-hour break, he came in, spoke for about another half hour, and then he was done. And I don't know if he never intended to address this, but I thought it was extremely important, and that is to focus explicitly on the justification for the use of force in that last 90 seconds before the paramedics showed up. Because it was only in that last 90 seconds that any of the officers were aware, and we don't even know if Chauvin knew this. There's no actual evidence that Chauvin knew this. But it was only that last 90 seconds that any of the officers was aware that Floyd apparently had no pulse. They checked for a pulse. They were unable to find one. Now, not finding one doesn't mean there isn't one. These are not medical professionals. These are the person who checked. It was his fourth call as a police officer, so hardly experienced. But nevertheless, he at least was unable to find a pulse. He attempted to communicate that to Chauvin, but it's very unclear whether Chauvin actually heard that information. So Chauvin himself may not have known, even then, that there was no pulse. But the point is, I think, clearly if Floyd had not died, none of us would ever have heard about this case. And it's in the last 90 seconds that we have some indication that death is on the doorstep. So that suggests that everything up to that last 90 seconds would not have been a problem, would have been lawfully justified. And it's only that last 90 seconds that is really critical. In fact, it's an open question in my mind. Everything could have been lawful up to that last 90 seconds, but does that mean the last 90 seconds is enough for a conviction? Frankly, I don't think that even then guilt was proven beyond a reasonable doubt, given the many other drivers that participated in Floyd's death, including the 90% coronary artery blockage, the pathological enlarged heart, the hypertension, unbelievable hypertension, the tumor, whatever that's worth, the toxic fatal levels of fentanyl in his system, the meth in his system. This was not a healthy guy. This was a fragile guy, despite his physiologically fragile, despite his size and apparent strength. And I would have spent a lot more time focusing on that last 90 seconds because I think it's quite possible the state might have been unable to convince the jury beyond a reasonable doubt up to that point, but then got most of their traction in that last 90 seconds. Now, I'm not sure it would have helped, really, because I don't think that this verdict is really based on the legal merits of the case. I think it was based, given how quickly they came back in deliberations, I think it was driven by fear of violence generally to the community and harm to themselves and their families, their careers, everything. I mean, life as they knew it would have been ended is probably what they were thinking. But of course, when you're going into closing, you don't have the verdict yet. So you don't know that it was going to be that fast and that apparently emotionally driven. You have to presume that the jury's going to do what they told you they said they were going to do when they were selected, and that is to be impartial and listen to all the evidence and apply the law as instructed to the evidence of the case. I don't think anything of the sort happened. So I think if Nelson had done a perfect legal defense, and his was not perfect, it was very good. Perfect's probably an unreasonable expectation, but it wasn't perfect. And maybe only a perfect defense would have made the difference, or maybe even that wouldn't have mattered because ultimately I think the jury didn't decide this on the legal merits. Okay, so that's what I have to say on that. Let's see. We got a question here from one of our Platinum members, Gary. And Gary asks, well, it's kind of a complicated scenario, but there's really one facet of it I wanted to touch upon, and it involves shooting someone in the back as they're running away. And of course, we all generally believe when we hear this, someone was shot in the back, well, that can't be lawful, right? Shooting someone in the back, what's more heinous than that? Clearly, they weren't a threat to you if you shot them in the back. But in fact, of course, there are plenty of circumstances in which shooting someone in the back is lawfully justified. One is there's a delay in your response, and they see your gun and they twist away from the muzzle. And in the next 0.2 of a second or whatever, that's when you fire the shot. When you made the decision to fire the shot and your body started that mental, muscular, activity, he was facing you. But by the time the shot got fired, 0.2 of a second later, he had turned away and the bullet ends up striking him in the back. What matters for legal purposes is not what the aggressor's conduct was when the bullet strikes him. What matters is what the conduct was when you made the decision to fire the shot. And in dynamic, physical, violent confrontations, people can be spinning and moving quite rapidly. And you end up with shots to the back that were not intended, that those were not the circumstances when the decision to fire the shot occurred. Another way, of course, that someone can get shot in the back is they were still a threat. So they may be running away and then reach behind over their shoulder and point a gun at you. You fire back, you end up striking them in the back. That's perfectly lawful if they were in an imminent deadly force threat when they were pointing their gun over the shoulder at you. You're entitled to defend yourself just as if they were facing you. It's no different. But your bullet ends up hitting them in the back. That doesn't mean it wasn't lawful self-defense. Or another scenario is if you're shooting not in defense of yourself. So they're genuinely not a threat to you. Maybe they've never been a threat to you, but they're an imminent, unlawful, deadly force threat to some third person, to some other party. This could be a active shooter in a mall or a school. And they got a long gun and they're gunning down, shoppers in the mall or children in the school. You shoot that person in the back. Is that a justified use of force? It's certainly, if it would have been justified to shoot them in the front under those circumstances, it's justified to shoot them in the back because you're acting in defense of third persons. By the way, folks, that same dynamic can arise when we consider distance shots. You might think, well, I'd never have to be able to shoot someone, in a justified use of force at 30 yards or 40 yards or 50. If they're that far away, I'll just run. Well, that's fine if you're talking about defense of yourself. But what if the people they're threatening are not 30 or 40 or 50 yards away? They're shooting people laying on the ground 10 feet in front of them. You happen to be 30, 40, or 50 yards away. You can use deadly force in defense of those innocent victims who are being murdered. And you might have to take a 30 or 40 or 50 yard shot to do that. That's a hard shot with a handgun. Long gun would be pretty useful under those circumstances. But just because the shot is long does not mean that there cannot be circumstances under which it would be justified to take the long shot, even to take the long shot and shoot the person in the back. It all depends. It's always the same question, folks. Was that person that you shot, you used deadly force against, were they apparently, reasonably presenting as an unlawful, imminent, deadly force threat to an innocent person? If they were, you can lawfully use deadly defensive force in protection of yourself or that third party. Let's see. Bill S., one of our platinum members, sent in a question. That's really a gun question. I addressed this earlier. I'm sorry, Bill. We don't really do gun law. It has to do with if a gun's in a holster, is that concealed? Is that open carry? If it's covered by a jacket, does it change anything? I could make statements about that, but it wouldn't be from a position of expertise. It would just be as a guy who's concealed carried guns his whole adult life. And because I don't claim expertise there, I wouldn't want to give an opinion, especially in this kind of forum. You need to talk to a gun lawyer. By the way, there is a company we partner with, concealedcarry.com, has a very good book on state laws in all 50 states. I don't remember. Sorry, folks. I usually keep a copy here at my desk, but I've been away and it's not here. But if you go to concealedcarry.com and search around, I'm sure you can find their book on gun law for all 50 states, and I found that to be a very helpful guide. What else? Let's see. James F. sent in a question. He asks about CCW Safe. He wants to know, do they provide documentation, basically their contract of terms with clients? Because many of these companies that offer similar services don't, folks. Basically, they just make a marketing pitch. Hey, send us money every month. You get in the jam, we'll have your back. And then there is no actual written agreement that tells you, well, what's the scope of that? Are there exceptions? Or the things I might do that might disqualify me from coverage? What's the extent of the coverage? What do you actually cover? Doesn't have any of those details. You definitely don't want to be giving money to people if you don't have things in writing, folks. Legally speaking, if it's not in writing, it does not exist. Now, having said that, I do not work for CCW Safe, so I can't speak for them. I'm not an employee of CCW Safe. We partner a lot. I think a lot of those guys, I think they do great work. I think they're probably They're among certainly the two best self-defense, quote-unquote, insurance options out there for people to consider. That's why I partner with them, because I think they're a good option for people to consider. But I can't speak to their contract language or anything like that. You would have to do that. Now, I know they have that available, and I would just suggest that you go to their website. There's a support email or support phone number there. They have great people on staff, and I'm sure they'd be happy to provide you with whatever documentation they typically make available, answer whatever questions you have, and so forth. But you'd have to go to CCW Safe for that kind of CCW Safe information. All right, folks, I think I've had, that's everything I wanted to touch on from the questions that were sent in. Let me look through first the Facebook. Let's see. Joseph DiMartino on Facebook asks about a Florida case. I have not read the case, and of course, I don't have time to do it now. We only have a couple minutes left together, folks. I do try to keep these within the hour. But basically, he asks, can you shoot someone because you're afraid of what they might do in the future? Well, if by might do, we mean, can you shoot someone because of a speculative fear? The answer is no. Someone says, hey, I'm going to go home, get a gun, come back here and shoot you. That would be a speculative danger. It might happen. It might never happen. If they come back with the gun, it's no longer speculative, right? But there's a period of time before it actually qualifies as an imminent threat. And you define imminence in this context as, is there ability, opportunity, and jeopardy? Until ability and opportunity exist, ability, opportunity, and jeopardy exist, there's not yet an imminent threat. If there's not yet an imminent threat, you can't yet use deadly defensive force. But if by what they might do, we mean someone threatens to shoot you and then reaches to their waistband as if they're about to present a gun. Well, that looks like an imminent threat to me, reasonably perceived as an imminent threat. They've told us they're going to use deadly force against us. They're reaching for an apparent weapon. Do we know for a fact they're going to shoot us? Well, no. And what if they pull out an apparent gun that later turns out to be a toy? Well, they never had the opportunity, the means to actually cause us deadly bodily harm. That's not what counts. What counts is, did they apparently have the means to cause deadly bodily harm? So you have to understand imminence in the context of ability, opportunity, jeopardy. Until that's achieved, there can be no justification for use of deadly defensive force. So if by might we're talking about a speculative or hypothetical future risk or threat of danger, then no, you can't use force against that. Let's see. I talked about the feds getting involved in Arbery. I haven't done it in a substantive way because, frankly, I'm waiting to see some documentation from the feds, some charging documents, something I can get my teeth into so I can provide a more detailed analysis. Was Chauvin entitled to a bench trial? Yes. Now, when a defendant's entitled to a bench trial varies a lot depending on the state. Under Minnesota law, in some states, the defendant can't elect a bench trial by himself. The state has to agree. Both parties have to agree. That's not the case in Minnesota. It's not the case in Minnesota, the defendant has an absolute right to a bench trial if there's pre-trial publicity that would complicate getting an impartial jury, which obviously was the case in this trial. So yes, Chauvin could have demanded a bench trial. The trouble here is, given the political heat around there, if you have a bench trial, so for those who don't know, a bench trial is when there's no jury, the judge is acting both as the determiner of law and as the finder of fact. He's acting as the jury. Well, in that case, to get acquitted, you have to believe the judge is willing to take 100% of the political heat of handing down an acquittal. And there can't be a hung verdict, right? There can't be a hung jury because there's no jury. So that's off the table. So the only choices now are guilty or non-guilty. There's no mistrial possibility. Because there's no jury-driven mistrial, because there's no jury. So unless you feel the judge would be willing to take that heat, then there's no point having a bench trial because you're just going to be convicted. With a jury trial, maybe you convince at least one juror that there's reasonable doubt. You get a hung jury. Maybe you get lucky and you convince all of them. The state hasn't proven their case beyond a reasonable doubt. But at least you have 12 people to work on in the course of the trial. You're not dependent upon just a single judge. Let's see what else. Jury interviews. This is the last thing I'll comment on before we shut down, folks. I rarely pay attention to what jurors say after a trial. They're just subject to too many political pressures, community pressures, social pressures. Their brain will recollect things in a way that's consistent with the least pain for them after the verdict has been rendered. We have no idea if what they're saying is really what happened in deliberations. It's such an intense environment in which recollection, how that recollection is recounted, can be biased in unpredictable ways. Now, it is relevant that at least some jurors are coming out and saying they were scared to death of the riots happening again. That's clearly a basis for arriving at a verdict that's not consistent with the legal merits, but is driven by fear of the mob. So that'll definitely be relevant to appeals. But other than that, you have to take everything those jurors say with an intense grain of salt after the fact, folks. I wish that wasn't the case, but that's just the way it is. All right, folks, with that, we're just about at the top of the hour, and I do try to keep these to an hour. I'm going to wrap things up. As always, I would encourage you to, at the very least, folks, take advantage of our free podcast of this show every week, lawselfdefense.com/free podcast, if that's the kind of thing that you might be interested in. And again, please do yourself a favor. Negative risk opportunity. Try our lawselfdefense.com trial membership, 99 cents for 2 weeks. If you want your money back in that 2 weeks, we'll give you twice your money back. So you can't lose, folks. And people really don't cancel their memberships once they sign up. They find the information sufficiently valuable that it's worth the roughly a quarter a day. So I encourage you to avail yourself of that opportunity at lawselfdefense.com/trial. And with that, folks, that's the end of this week's Law Self-Defense News and Q&A show. If you liked it, tell your friends. Again, you can always capture the recording either at Facebook or the lawselfdefense.com/blog after the fact if you can't make the live show. And with that, remember, folks, if you carry a gun, so you're hard to kill, that's certainly why I carry a gun, so I'm hard to kill. My family is hard to kill. Well, then you owe it to yourself and your family to make sure you know the law so that you're hard to convict. All right, folks, I'm Attorney Andrew Branca with Law Self-Defense. Stay safe.